I invited Michael Bisonet and West Coast Environmental Law to give us this talk today. And of course, this is one of many law firms that will probably be sharing their views on DRIPA and the Land Act. West Coast Environmental Law was formed in 1974. For those that you don't know, it's a not-for-profit law firm that is lawyers that are focused on safeguarding the environment through law. And I'll let Michael explain a little bit more about his background, but we're going to speak, I think it's about 30-minute presentation, Michael, and there'll be some questions, but I'll just say that again, we're not going to be in any position to answer questions on behalf of Squamish Nation. We can certainly share some examples of the work that each of the biospheres are doing. So, and if you could mute your, except for Michael, please mute yourselves and we shall get started. Over to you, Michael.
Thank you very much, Ruth. I'm just going to take 1 second to share my screen before I get started here. Ooh. Okay. Okay. Thank you very much, Ruth, for inviting me, and thank you everyone for coming out on this, or at least very rainy Friday morning here in Vancouver. I imagine you're looking at something similar, maybe with a little bit more snow in Howe Sound. Yeah, as Ruth mentioned, I'm a staff lawyer at West Coast Environmental Law. At West Coast Environmental Law, I'm part of a team that works primarily on marine law issues. I think it's also relevant to mention, before I worked at West Coast Environmental Law, I worked for about 8 or 9 years at a private law firm working for First Nations clients. So I guess, but I'm trying to explain that I did do a fair amount of Aboriginal law as well before I joined West Coast Environmental Law. And yeah, as Ruth mentioned, I think when Ruth initially reached out to me, the Land Act amendments were this was a few weeks ago. They were being proposed. There was a consultation period, and it was a real period of there was a lot of concerns being voiced from certain sectors of society, especially folks kind of in the resource sector, about what these amendments might do. Unfortunately, a lot of that generated a lot of concern, and the government has kind of decided to step back for the moment on these Land Act amendments. But I think there's still a lot of value in talking about this. In fact, I think a lot of people are still talking about this. Yesterday in question period in the legislature, this was a big topic of question period. And it's part of reconciliation, and it's part of the UNDRIP process. So I think what I took away, and I think what a lot of people took away from the last month or so, is that there was a lot of concern generated, and I'm going to suggest that a lot of it was kind of based on perhaps a bit of a misunderstanding, or essentially a misunderstanding of what was trying to be achieved, and kind of where we're coming from with these Land Act amendments. And so I think there's a lot of value in talking about it today, and that's kind of what I'm going to hope to do today, hopefully in no more than 30-35 minutes, so that if anyone has any questions or wants to talk about anything, we still have time for that. And so, yeah, my outline and what I'm hoping to do today is essentially, I mean, this is going to be quite brief. As you can imagine, some of these topics, you could talk about for a very long time, and many people have. But I think it's important to first kind of understand just a brief history of Indigenous rights in British Columbia. I'm going to do this in a very, very brief format. And then I'm going to talk in particular about the sources of protection for Indigenous rights in Canadian law. And there's kind of two main sources that are very relevant to the topic, and to why Land Act amendments were being proposed. One is Section 35 of our Constitution, and the other one is the UN Declaration on the Rights of Indigenous Peoples. And then hopefully with this background, we can then talk a little bit about what these Land Act amendments were trying to achieve and kind of what the criticisms were and maybe some responses to some of those criticisms. Okay, so a very, very brief high-level overview here of Indigenous rights. But a very basic idea that I think most people today would accept, although this hasn't been the case in the history of Canada and of British Columbia for sure. But there is this reality that there have been First Nations who have been living in what we now call British Columbia for thousands of years. They would often refer to to their time here as since time immemorial. And First Nations have been living here in their own organized cultures and societies, stewarding these lands and waters in keeping with their own Indigenous laws, their own Indigenous customs and governance systems. And from that, we often refer to First Nations as having inherent Indigenous rights and title to these lands and waters. And I just want to break that down just very quickly for you, but a couple key words there. First, the word inherent. So what I mean when I say that these rights are inherent, or that we kind of consider them inherent, is that they're not dependent on a government from Canada or British Columbia granting them these rights. These rights arise from their long-standing use and occupation and governance of these areas. So in that sense, they're inherent. They're not something that was granted to them by British Columbia or Canada. And then this is going to be very, very quick, but I don't know if everyone understands the distinction between rights and title. Title is often kind of, is technically just a subset of Indigenous rights. But when we talk about Indigenous rights, we generally talk about a right to a certain, for example, harvesting practice. So a right to fish in a certain area, or a right to gather berries, or a right to hunt, or a right to carry out certain activities. Whereas an Indigenous right to the land is what we kind of refer to as title. So that's, a right to have control and title of an area. Okay, so there are these rights that are inherent rights that come from First Nations, long-standing, time immemorial, use and occupation of these areas. And historically in BC, as you're probably aware, there were very few treaties that were entered into when the Crown arrived, when Europeans arrived here in British Columbia, to try to regularize relationships with Indigenous peoples. Kind of European settlement and arrival really happened kind of first on the coast. That was more accessible at that time. There was, a major fort of the Hudson's Bay Company at Victoria. And in the 1850s, there were several treaties signed. I think there's 14 treaties on Vancouver Island that are referred to as the Douglas Treaties. James Douglas was the chief factor of the Hudson's Bay Company at the time, and the person who entered into these treaties on the European side. There was these treaty making at the beginning, and you may be also aware that there's a part of northeastern British Columbia that's also subject to another treaty, Treaty 8. So this is kind of on the east side of the Rocky Mountains in northeast British Columbia. That was signed kind of in the very beginning of the 20th century. But outside of that, historically, there were very, very few treaties signed in British Columbia to kind of regularize our relationship with Indigenous nations. And instead, the approach that the government decided to use, this is also under the colony of British Columbia, and subsequently kind of when British Columbia joined Canada. I'm simplifying a lot here, but essentially after these Douglas treaties were signed, they kind of moved away from signing treaties for a number of historical reasons. And instead, they essentially decided to try to address the land issue, or the issue of Indigenous rights and title, by kind of ignoring it and setting up a different system instead. And so what kind of happened mostly is that reserves were allocated to Indigenous peoples that came to be administered under the Indian Act by the federal government. And I use the word allocate here because these were not reserves that were, or these were not arrangements that were done in some kind of necessarily mutual agreement. This wasn't a treaty process or anything of that sort. It was more kind of commissioners who kind of traveled across British Columbia and visited communities, First Nations communities, and said, you know, there's your land. We're going to allocate this little spot. That's your reserve, the land that we're granting to you. And while that was happening, the province was opening up the remaining lands for settlement. And ironically enough, for our discussion today, that was mostly done through the Land Act. So under the Land Act, non-Indigenous peoples could preempt land. And what that basically meant is you could go out and stake a piece of land of a certain, I can't remember how many hundreds of acres it could be, but of a certain size. And if you put in enough work on that piece of land and paid a very small nominal fee, the Crown granted you title to that land. And so that's kind of the system that was in place in British Columbia for a very long time. That, you know, the bones and the parts of the system are very much still in place. But that was kind of how settlement kind of took place. And it was a very oppressive system for First Nations. They were excluded from all of their traditional territories, put onto reserves, and didn't have any say on what was happening outside of these. And the conditions that they were being, that were imposed on them by the federal government in these reserves were quite oppressive. I think everyone probably has some understanding of some of this, but their cultural and governance practices were outlawed. So things like the potlatch, which were integral to many coastal First Nations, were outlawed. Things like, obviously things like residential schools, which had, awful abuses were imposed on them. And even things like, for example, for decades under the Indian Act, it was effectively impossible for First Nations to even hire a lawyer to litigate or to stand up for their Indigenous rights. So we had this really, really long period of this very oppressive system that essentially ignored this issue of inherent rights and title of Indigenous peoples. This lasted for a very long time, and in some extent is still, as I said, part of our system today. But it did change in say the last 50 years, where there were some major legal changes that kind of changed the way that this is happening. And that's what I want to talk about now. In the 60s and 70s in particular, I think there was a real resurgence of activism for Indigenous rights and organizing around that. And one of the big legal victories of that movement was in 1982 when Canada enacted Section 35.1, but Section 35 of the Constitution, which recognized the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. There's a really amazing history to how this came about. This was during the repatriation of the Canadian Constitution, the enactment of the Charter, but there was incredible activism for Section 35 as well. You may have heard that there was a Constitutional Express, a kind of train ride across the country, drumming up support for this, and a lot of real movement to get this to happen. And this was a really crucial, very important protection for Indigenous rights in Canada. This effectively meant that governments couldn't ignore these or shouldn't be able to ignore these anymore, because suddenly Aboriginal rights and title had constitutional recognition. And so that means that the governments can't just enact laws that completely ignore them, or go on in the system that we've had for a long time of ignoring these rights altogether. But there were still a lot of issues. So after 1982, there's quite a few legal decisions or Supreme Court of Canada decisions that come out that kind of give us they kind of lay out the test for these Aboriginal rights and the duties imposed on the Crown in terms of respecting these Aboriginal rights. And so throughout the 90s, you get some really important decisions that do this. You may have heard, for example, Delgamuukw, which was kind of laying out the test for Aboriginal title. There's a Sparrow decision where we talked about fishing rights, and these were all positive. Like a lot of these were major victories for First Nations in court, but there was still a really big problem, which was these tests that were laid out to prove Aboriginal title in court and to get this recognition were really, really onerous. So you had to show evidence, historical evidence going back, sometimes hundreds of years of your control and use of an area. And you had to hire lawyers to get into court. And, these were really, really big, expensive undertakings for First Nations to take, and especially for, First Nations governments who had been excluded from their land base for so many years and from the profits that were made on it. So even post 1982, we kind of had this issue where, okay, rights are respected, and the government we know has duties when these rights are recognized or when a treaty is signed. But effectively for most First Nations, this didn't really change anything because they just weren't able or hadn't had the chance yet to go to court and prove their rights, or to get a treaty to recognize the rights. And so we kind of continued in this period of kind of ignoring this issue in some ways. And that really changed dramatically, I would say in 2004. And I'm going to suggest that this is one of the more consequential decisions on Aboriginal rights that happened in 2004. And that's the Haida case from the Supreme Court of Canada. And so I'm just going to talk about this briefly. I think it's just the one decision that's really important to kind of understand for everything else that I'm going to talk about. But essentially, the Haida were pursuing their title claim to Haida Gwaii, which was referred to as the Queen Charlotte Islands at the time. And the Haida were doing this process I'm talking about, trying to gather evidence and get to court and get their title recognized. But while this is going on, their lands are being, continue to be logged, continue to be clear cut. And, there's this kind of this realization that, we might get to the end of this process and get a declaration of title, but we might get a declaration of title to a land base that's just effectively a big clear cut. And that's a land base where you lose all the cultural value of that land, the economic value, everything the title is supposed to be protecting could be gone by that point. And so the Haida went to court challenging logging decisions in their territory and said, listen, we're trying to get declarations of title, but there should be some kind of duty on the Crown to consult and accommodate with us in the meantime, while we're trying to get this declaration of title. Otherwise we might not have anything to protect once this is over. And the Supreme Court of Canada agreed with the Haida Nation and found that when the Crown has awareness of a claim of Aboriginal rights and title to an area, or there's a credible claim to it, and they're making a decision that impacts or could potentially impact those rights, they do need to consult with that First Nation about that decision. And so that was a real kind of shift in how decisions are made in Canada, especially in British Columbia, where we had gone through this period of essentially ignoring this issue of Indigenous rights, for, over 100 years. And now that could no longer continue in that way. And so we had this duty to consult, but it's a very kind of uncertain duty. As the court explained, the duty can range. So you might be required to make very deep consultation on one end of a spectrum, or in other cases, you might actually just have a very small duty to consult. And the court said that there's basically two factors for that to determine how deep this duty is. The first one is how strong is the claim to Aboriginal rights and title? Does this First Nation have a very strong claim, a lot of evidence? In the case of the Haida, that answer was yes. And then the second question is, how big of an impact is this Crown decision on that title? And so in the case of, for example, something like clear-cutting lands, that's a very, very high impact on lands. And, like other industrial projects like mines, tailings ponds would also be something that has a great impact on rights and title. And so when there's a strong claim to title and strong impacts on title, the duty on the Crown is going to be very, very steep to consult with the First Nation. Essentially, it's going to be, they should be treating them almost like they do have title to these lands. And so we had this new kind of framework and this new duty to consult, but it was messy, and it still is messy because, first of all, First Nations and the Crown governments don't always agree on the level of consultation that should be required. They don't always agree on how that consultation should take place. And that's led to a lot of litigation where First Nations will sue the government for failing to meet its duty to consult. And so it's been a messy period with a lot of uncertainty because of this duty to consult. And a lot of people have been working and thinking about how to overcome these issues. The big way that people are doing this to try to regularize these relationships and make it easier is to say, hey, what if instead of having this weird duty to consult where it's kind of reactive on First Nations and no one's really satisfied with what's happening, what if we work together? What if we made decisions together? What if we co-managed lands together? What if it was more of a harmonious relationship? That would give us a lot more certainty, and it would get rid of this antagonism, and it would be great for reconciliation. And so that's been kind of since 2004, there's been a lot of these initiatives to do this. And in fact, in Haida Gwaii, not too long afterwards, they enacted a Haida Reconciliation Act in Haida Gwaii. And it essentially lays out a way that they can jointly make decisions in Haida Gwaii between the province and the Haida. And they've established boards to do that and an act to support that. And that's how they're moving forward together. But that isn't that hasn't been the case, everywhere. And there are those kinds of agreements like the Haida have and statutes like the Haida have everywhere in BC. So that's been, that's been a big subject of discussion, and a lot of initiatives in BC are really focused on that right now. And I'm now going to talk about another source of protection for Indigenous rights that also kind of speaks to this issue of co-management and how to make it easier. But so I'm going to talk about the UN Declaration on the Rights of Indigenous Peoples, often just kind of referred to by its acronym UNDRIP. So this is an international law document that was adopted by the UN in 2007. Canada, I believe with a couple other countries with similar colonial histories to Canada, initially opposed it, but in 2016, Canada endorsed UNDRIP. Oh, sorry, I should also mention, so what UNDRIP is, it's a collection of 46 different articles that kind of lay out different rights for Indigenous peoples worldwide. And they're meant to be kind of minimal standards for the survival, dignity, and well-being of Indigenous peoples. And so some of them, are about cultural rights and governance rights and stuff like that. And some of them also do look a bit more like Indigenous rights entitled, like having some say over decisions in your territory, making sure that your rights in that way are respected. But so one of the issues, though, with an international law instrument is that you need, for it to have effect in your domestic laws, in your domestic country, you need to enact laws here to implement it. And now we are in this position here in Canada and in British Columbia, where both the federal government and the government of British Columbia, did it first, have enacted statutes whose purpose is to implement UNDRIP into domestic laws. And the BC statute is called the Declaration on the Rights of Indigenous Peoples Act. The acronym is DRIPA. So if you can remember this, DRIPA is the act that seeks to implement in BC UNDRIP. DRIPA was enacted in 2019. It was unanimously enacted, which is perhaps a bit surprising just given the kind of level of debate that there's been in recent months. But I think it's important to remember in 2019, every MLA in the legislature approved of DRIPA. And I think I'm going to talk a little bit about what this act does. But I think really, if you want to think about it, kind of the purpose of this act and what it's trying to achieve is to find ways that First Nations and BC can work well together. And so there's kind of two things I'm going to highlight from the act. The first one is that the act is really its focus is on making sure that the laws of British Columbia are respectful of UNDRIP rights. And so there is this provision that the government is required to take, in consultation and cooperation with Indigenous peoples, all measures necessary to ensure the laws of BC are consistent with UNDRIP. And in order to do that, they're required to create an action plan, and they're required also to report on that action plan on a yearly basis on the progress that's been made. And so here in British Columbia, the government, in cooperation with Indigenous peoples, prepared an action plan. I think it's a 2022. It's a 5-year action plan. You probably would not be surprised to know, but one of the purposes of it, or one of the actions in this action plan, was to do stuff like the Land Act amendments that we're discussing today. The other big thing that UNDRIP enables enables BC to enter into agreements with like a specific First Nation to exercise statutory powers jointly. That's quite significant because, as I discussed, how consultation generally occurs under the HIDA agreement is that the BC government has the last word, and it kind of engages with First Nations in consultation processes that are often very unclear on how they're going to take place. And then it makes a final decision. But there could be a way that they could both work together and jointly make that decision, which would provide a lot more certainty and clarity to how everything's happening. And the only catch with these DRIPA agreements is that if they're going to give a statutory power or a power to jointly make a decision together, the statute actually has to allow that. So that's the problem right now with the Land Act, is that it doesn't actually allow for joint decision making. So you can't make an agreement under DRIPA that would allow for joint decision making under the Land Act. There are other statutes right now that do allow joint decision making. And so since 2019, when DRIPA was enacted, there's only actually been 2 agreements that have been signed under this provision. And those were both with the Tahltan First Nation, who's in northern British Columbia. And they were, I believe both of them were to allow joint decision-making powers under the Environmental Assessment Act. So what was going on is that there were mining projects proposed in Tahltan territory. And the province knew that it has a significant duty to consult with the First Nation about these projects. And they said, you know what, why don't we come to an agreement on how we're going to make a decision on these mining projects? So they entered into agreement that laid out the framework on how they were going to do an environmental assessment of this mining project and come to a decision together. So there was two of those. There's only been two since 2019. And that's kind of effectively what these Land Act amendments were trying to do, was to enable that kind of agreement, but on decisions under the Land Act. Okay, I'm going to talk very briefly about the Land Act, but the Land Act right now, it's changed since I talked about it historically, where it was this kind of tool of preemption and of taking lands. The language has changed in the Act, but the Land Act is still the main statute that manages Crown lands in British Columbia. And that doesn't just include the land portion. I work on marine law. And if you need to get some kind of authorization or license of occupation or permit for the seabed in many areas of British Columbia, you need a permit under the Land Act for that as well. So that, for example, in Howe Sound, if there was some kind of use of the seabed that required fixing to the seabed, you would need some kind of authorization under the Land Act. So it's quite a major act, and it's definitely the predominant act for kind of regulating what happens on Crown lands in British. There are specific statutes for forestry. There's specific statutes for oil and gas operations and those kinds of things. But this is one of the main statutes for addressing that. As I said, right now, it doesn't allow for this kind of joint decision-making between the province and First Nations that, for example, the Environmental Assessment Act right now permits. Okay, I think I'm getting to my last slide, so I hope everyone's still staying with me. And I'm just going to talk a little bit about some of the criticisms and kind of my responses to them of these changes. So I just took this quote from a Globe and Mail article, but I think it captures kind of the worries that these Land Act amendments are bringing. So the magnitude of this potential change to British Columbia's governance and regulatory regime over Crown land is unprecedented and could result in an untenable and unworkable Crown land governance and regulatory regime. Okay, so the first thing I want to say about that, and I think this is a really important point, is that the potential change from the Land Act amendments, the amendments on their own are not going to change absolutely anything about how land decisions are made in British Columbia. As I mentioned, all they would do is essentially give the government another tool that it could use to make decisions. And in this case, that tool would be entering into agreements under DRIPA to allow some kind of formal joint decision-making with First Nations about a particular project or perhaps a particular piece of land or something to that effect. And as I've said, since 2019, so we're 5 years later, we've only had 2 of these agreements entered into, and they were about very specific projects in the heart of Tahltan territory. So in terms of the potential change to British Columbia's governance system, I would suggest this is not that. This is not the magnitude of a potential change is going to be enormous. All it's going to do is give a tool that the government could use to satisfy its duty to accommodate and consult with First Nations by going into agreements. And then the second point from this quote that I kind of want to speak about is that it could result in an untenable and unworkable Crown land governance and regulatory regime. And so this was the point I hope that you're understanding why I feel like that's wrong. That was kind of the point of my presentation. But my point being, since the Haida decision, and governments no longer being able to ignore Aboriginal rights and title, the system has been a little bit tricky and unworkable sometimes, and sometimes untenable. And these kinds of Land Act amendments are specifically designed, or the entire point of creating this kind of tool was to make it more tenable and more workable. We can continue. It's in our Constitution. It's not negotiable. The government can continue to try to solve its and satisfy its duty to consult with First Nations through consultation processes that aren't well defined and that can lead to a lot of conflict. Or they can work with First Nations and they could set out agreements that make it clear on how a decision is going to be made. They can set timelines for how that decision is going to be made. And it seems to me that that kind of approach is much more predictable, less risky, certainly more tenable and workable from my perspective than where we are right now, where there's just a lot of uncertainty about these issues. So yeah, I think that's the message I wanted to convey. This would have been a welcome tool to enable better arrangements and co-management and co-governance of areas. And I think we should welcome that. I think the House on Biosphere is certainly a place where folks are trying to think about ways to work effectively together. And this kind of tool could help in those arrangements. And I think the other point I want to make is that this continues to be kind of a topic of controversy right now. And but I think it's important to understand that we need to continue to do stuff like this. We adopted DRIPA in 2019 unanimously, and the point was to try to change our laws so that we can work together better in a respectful way. And so we're going to need to change more laws and do so in this way. And so I think it's important to understand why we're doing this, and so that we can, not get stuck up on what are, ultimately somewhat minor amendments to the Land Act at this point. Okay, I think that's all I wanted to convey today. Thanks a lot for listening, and I'm very happy to answer any questions anyone might have.
Thank you, Michael. Thanks so much for taking a lot of information, broad topic, and putting it into this really concise presentation. So thank you. Maybe if you want to stop sharing your screen, we'll look around the room. You're welcome to turn on your video. And there's some new folks that have joined us today that are part of our House Sound Roundtable. So welcome to you. And you get to see who we are. So questions for Michael? Yes, Greg.
Well, thank you so much. Great presentation. Covered a lot of ground and a lot of time in a short period. I've been working with First Nations since 2004, which is sort of a auspicious time to begin. And one of the this Haida versus BC decision that the Supreme Court made seems to have some variability in how consultation occurs with fresh water. I know in a lot of the terms you use today, a lot of the reference to acts, I'm wondering if you can speak to this uncertainty that I hear about in terms of the referral process on freshwater decisions and consultation. And I hear about the uncertainty both from First Nations themselves in practice, but also from law firms that specialize in Indigenous rights and title.
Yeah, thanks for your question, Greg. I don't know if I can say anything particularly unique about freshwater, but I think I should I'll make 2 points that are hopefully helpful. But I think the one point, and I think, Greg, you're probably aware of this, but the other thing that is challenging about the duty to consult and post the 2004 Haida decision is that Indigenous governments had to get the capacity to engage in this. Suddenly, you were going from a reality where Indigenous governments were just ignored on land use decisions, mostly prior to this, to now the government had to reach out to them to consult. And so I'm not going to speak. I think the Squamish Nation is probably one of these governments. I'm not going to speak on their particular issues, but where suddenly they were getting, hundreds, if not thousands, of referrals to consult on decisions. And you can imagine, to even engage in any of that, you really needed to have the capacity to actually understand what the decision was and provide some kind of value to it. And so that was really challenging. But yeah, Greg, the real challenge with the duty consult is the variability on it. Because the idea is we need to start treating these rights as if they exist prior to proof in court. And so what's really challenging is where on the spectrum of the duty to consult, the Crown has kind of said there, or the Supreme Court has said, at the far end of the spectrum when there's a decision that's going to really impact their rights. So I would imagine in the freshwater context, something that's going to really damage or, dirty fresh water or divert it or something in that effect. And this nation has a really strong claim to Aboriginal rights. You should essentially treat them as if they do have those rights. And so it's getting close to essentially, you should definitely be seeking their consent on these kinds of decisions. But then you've got the other end of the spectrum where there might be decisions that have very little impact on rights, or, this nation might have, I don't know, a contested claim to fishing rights in this area that isn't very well supported. And in that case, your duty might just be to inform them and maybe gather some feedback. But that problem of the spectrum of where you are in the duty to consult is just kind of hasn't been resolved. It leads to a lot of litigation, and it leads to a lot of differing opinions and uncertainty in the law.
Thank you. Killian.
Yeah, thanks, Michael. That was really, really helpful. I was just wondering if you had any idea on how these proposed changes were going to deal with sort of overlapping or contested territory, because the case like the Haida or Tahltan, it's a lot more straightforward. But when we're talking about the BC coast, there's a lot of overlapping territory, right? And I can imagine that getting really complicated when you're trying to set up a decision-making structure.
Yeah, thanks, Killian. That's a great question. First of all, I would suggest that we're probably only going to get DRIPA agreements for the foreseeable future in these very clear-cut situations. I'm sorry, again, I can't speak on Tahltan rights, but I imagine where these agreements were concluded, very, very strong claims to rights entitled by the Tahltan, and probably very little, if any, overlapping claims. Because you're absolutely right. If you conclude one of these agreements with one First Nation, but there's other nations who have claims to rights in this territory, you still have to fulfill that duty to consult. And so you've still got this problem where you're going to have to make a joint decision, but you're also going to have to consult with other folks as well. And so I'm imagining that these agreements are probably going to be focused on areas where there isn't those overlapping claims. But that is a great, that's a real challenge for governments in areas where, you might have 8 different overlapping claims of rights that you need to all consult with. It's very complicated. It's very difficult. I don't know if these agreements are going, you might be able to get some kind of very complicated agreement with all these nations, but I suspect we're going to start with very clear-cut cases of rights and title.
Thank you. We have a question in the chat from Judy, Tourism Bowen. Can you speak to the difference between elected chiefs and hereditary chiefs and how this relates to DRIPA?
Yeah, absolutely. Great question. Okay, so I don't know how much you absorbed of my overview of Indigenous rights, but as I spoke about, there's been nations living since time immemorial in British Columbia under their own laws, customs, and governance systems. So, for time immemorial, there's been governance systems in place in British Columbia. And essentially what happened is in that history, when I kind of talked about how the governments decided to kind of sidestep this issue of Aboriginal rights, and they just allocated reserves for First Nations. When they allocated those reserves, they essentially set up governance bodies under the Indian Act, known as Indian bands, that would be responsible for administering that reserve. And so those were the Indian Act bands that were created under the Indian Act. And the result of that is that we had these kind of two different governance systems. We had the traditional Indigenous governance systems, and then we had these new Indian Act bands. And there's a conflict between these two sometimes. In some First Nations, there's less of a conflict. They might kind of effectively be the same governments and work together. But in some First Nations, there's differences between these two. But what's really important to note is that those rights, Aboriginal rights and title, are inherent. And the Canadian government can't, like what it did with the Indian Act, it can't allocate a government to be in control or to be the spokesman for those Aboriginal rights. That is something that only the First Nation can do. And so, yeah, we do have this conflict. I think we've seen this conflict play out a lot. For example, if you've been following the Wet'suwet'en kind of pipeline protest, there is this real conflict between the bands and the traditional Indigenous governance system. But to be clear, under kind of Supreme Court of Canada law, the Indian Act band is not the spokesman for Indigenous rights and title.
Thanks, Michael. Sorry, it was Jody, not Judy. Great. Any other questions, Ian?
Yeah, thanks, Ruth, and thank you, Michael. Very informative. So the question that I have, I guess, relates to how we got to this point with the province and the rollout of the amendment in the Land Act, and obviously a failure in communication is the way I see it. So in your opinion, how, as we move it forward now, what needs to be done to communicate better, to make sure that the people, 4+ million people in the province, understand how it impacts them, and even if it does? So what needs to be done differently?
Yeah, thanks, Ian. A great question. Yeah, so I think the government, I can't speak for them, but I think they were hoping that this was going to be viewed as like a very technical decision, and they wanted to keep this under the radar. And so they didn't communicate about it when they rolled it out. In fact, even, those of us who work on these issues and in NGOs and stuff, I think a lot of us found out about this for the first time when we heard about the outcry about it from other sides. So yeah, from a comms perspective, I think that was a real failure. A couple things I want to say about that, though. So when the government decided that it wouldn't go ahead with these Land Act amendments at this point, the BC First Nations Leadership Council kind of issued a statement. I'm just paraphrasing it, so please don't quote me on this, but they essentially said, it's really too bad that we're still, like, we enacted UNDRIP unanimously in 2019, and it's really too bad that we're still kind of having this conversation. And the other thing that at least I took this to heart, they were saying it's really too bad that it falls on First Nations that constantly have to explain these things. And so I agree with you, Ian. I think folks like West Coast Environmental Law organizations that work on this, I think we need to remember that no matter what legal victories you get, whatever you get enshrined in the Constitution, blah, 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 it's still so important to explain and educate why these things were done and why they're valuable. And that's a constant process. Like, we can't just say, well, we got UNDRIP, we got DRIPA Act in 2019, moving on, we don't need to explain it or talk about it. I think that's that's what brought us to the situation. And so anyways, that's part of why I'm here today. And I think we need to do more of this. And certainly our government does too. I think they're hopefully learning their lesson here.
Thanks, Michael. Peter.
Yeah, thanks, Ruth. Thanks very much, Michael. That was an excellent presentation. I just want to make a comment and then follow that up with a question. And the comment relates to the exercise that the Gambier Island Conservancy went through back in 2013 and 2014, when the government established 2 large woodlots on Gambier Island and went out to tender to have to give out the logging rights for that. And they did not consult, never mind not consulting with the First Nations, but they didn't consult with the community. And luckily, as a result of our campaign against that, and we finally got in touch with the Squamish Nation, and we actually even spent some money, legal money, to counter this lack of consultation. But it was really letters from both the Tsleil-Waututh and Squamish Nations that actually put an end to that particular initiative by the government. And it seems to me, if these amendments to the Land Act had already been in effect, we wouldn't have to gone through that process. That would have been resolved a lot earlier. It wouldn't have caused us so much expense and anxiety for our conservancy. The question I have is regarding the recent nature agreement between the province, the grants given by the province and the federal government to work with First Nations on protecting and set-asiding land, 30% by 2030. I just wonder how this particular act might affect that initiative.
Yeah. Okay. So thanks for that, Peter. Couple things. First of all, the government's been very clear that, you know, if we're going to achieve these conservation targets, we need to do this in partnership with First Nations. Sorry, this is a whole other topic, but obviously there's kind of a dark colonial history to conservation as well, where a lot of in the past protected areas were set up that led to the displacement of First Nations from their lands. You know, Banff National Park's a great example of this, Kulani National Park in the Yukon. You know, a lot of these parks were created based off the displacement of Indigenous peoples. And I think a lot of folks in the conservation sector are very aware of that and are trying to find better ways. Yeah, as far as how the Land Act amendments could help with that, I think a great example, generally speaking, there's specific acts for protected areas. So generally when you're creating a protected area, it's going to be administered under the Parks Act. You know, there's a number of different acts that could create and administer protected areas. And so generally speaking, it'll kind of be, the Land Act will be slightly less relevant at that point when they're established. But the other thing that the Land Act could do is, you know, you could have decisions. For example, I'm not sure if you're aware, but there is quite a movement of Indigenous nations declaring their own what we call IPCAs, so Indigenous Protected and Conserved Areas. And so, you know, you could use this kind of joint decision-making process. For example, let's say Indigenous nation declared an Indigenous protected area. Again, I got a bias towards marine areas, but let's say to a certain bay, and they wanted to protect this area, and they certainly didn't want to have aquaculture operations in there or something like that. The provincial government could, you know, say, well, listen, if we get any Land Act requests for a use or occupation of this area, why don't we have a joint decision-making policy for how we make a decision on that? And so they could do stuff like that to support IPCAs. That being said, the general approach has been to try to get them designated under, like, for example, the Parks Act in BC or the Oceans Act at the federal level, or, you know, other laws that govern protected areas.
Thank you.
Great. Well, thanks so much, Michael. We're 1 minute to 11:30, and we know we really appreciate you doing such a great job at answering questions in this presentation today. I encourage, as I put in the chat there, thanks, Suzanne, for some of the links too, and the book from the Squamish Nations just published, We Come From This Land. Oops, you can't get that into my screen, but we're on a learning journey, and so please share the you know, the idea for people to keep asking questions, and there's a tremendous amount of resources. So if you have any questions for us as we go on, please reach out. But I'm going to keep this line open here for anyone that wants to stay around and just chat for a bit, but we'll let Michael go. And again, thanks so much for making the time.
Yeah, thanks for inviting me, Ruth. Appreciate that. Thank you.
And we'll say that West Coast Environmental Law is a not-for-profit organization and a worthy charitable organization for looking for donations at any time, right? As we all are, but wouldn't plug. So